Claire, I'm going to let you take over.
That's perfect. So here's a New York specific section, and we're talking about guardianship in New York. And when we're talking about guardianship, or whatever it might be in the state that you practice in your juvenile court or surrogates court or family court, we have different articles and different laws that govern that. Here in New York, it's primarily Article 6 of the Family Court Act, but also the Surrogates Court Procedure Act, as well as the Social Services Law. They all come into play in how we're entering family court, but also on how we're defining the various elements of abuse, abandonment, and neglect in the SIJS context. So don't just rely on the Family Court Act, and just don't rely on the Social Services Act, but look to all three. So we've talked already about what a guardian is, a custodian is, and remember that New York law allows for guardianships for young people up until the age of 21. It might be different in other states, and we know that it actually is, so this is New York specific as well. In New York, how do you start? You start with actual forms, and all the forms for family court issues in New York are available for free online on the New York State Family Court website. There's an actual guardianship petition, and that's Form 6-1 if it's the actual petitioner's petition, the proposed guardian's petition, and Form 6-1A if it's the young person's petition to have that adult appointed as his guardian. There's an oath for the guardian, that's Form 6-2, and that's a form saying that if this person is appointed guardian, he will do it to the best of his ability. Form 6-3 is the minor's preference or consent, depending on age. And then Form 6-4 is a consent or waiver of biological parents if they're able to be located and willing to sign a consent form saying that this person would be appointed as a guardian. That also goes into issues of service as well. And then there's the completed OCFS-3903 form. That's a mouthful. And what that is that is a form for the guardian, the proposed guardian, and all the adults living in the household to have all their addresses for the past 28 years listed, as well as their birth dates, so that here in New York, Albany can run a background check on them. So let's back up. When you're meeting with this young person and you're meeting with the family, you're not sitting down at your first meeting and saying, "Hi, I'm the lawyer. I need to know all your addresses for the past 28 years." Because nobody knows all their addresses for the past 28 years off the top of their head, unless you're just filling out your applications for licensure for the New York Bar, as we remember doing. There you had to list them. But give people time to come up with their addresses, and oftentimes those addresses aren't perfect, and that's okay. The court just likes to see that we have the dates covered, but if the person doesn't quite remember the street number, that's okay as long as the dates add up. We also need the child's birth certificate or some proof for their age and a translation. Everything that we're submitting to the asylum office, to immigration court, or to the family court or juvenile court, whatever it might be in the state you practice in, needs to be in English. So that translation doesn't have to be a translation that you're paying a lot of money for. It can be done for us. We have interpreters or volunteer interpreters or law students do them for free. It just needs to be done by someone who can sign an affidavit saying they're fluent in English and Spanish and whatever the language might be, and that they've translated it to the best of their ability. Okay, moving on. Service is something that comes up all the time in our guardianship and in our custody cases, and it's something we need to be aware of. We go into a lot more issues than service in our more in-depth training of SIJS, but what we know is that in family court here in New York, personal service is the norm. However, for a lot of the young people that we're seeing, they're in situations where they've been abandoned by one of the parents or by both of those parents. And we have New York law that says that in such case, in a guardianship case where there's abandonment, we don't have to use personal service by first-class mail to last known address is sufficient. So we'll talk to you, and as your mentor attorneys will work with you on trying to figure out what you can advocate to the judge to get around the norm in family court that is personal service when we're dealing with an abandoning parent in a different country. So again, here's just a little primer on the background check, and I get questions usually twice a week, sometimes 3 times a week, from the proposed guardian and the other individuals in the household saying they don't want to do a fingerprint check because they don't have papers. It's a question I get a lot, and when you think about it, it actually makes a lot of sense. If you've been living undocumented, you're afraid to go get fingerprinted. Here in New York, we can safely say that these fingerprints are done in the family courts and that information has not been shared with Immigration and Customs Enforcement. Okay, moving on. In your guardianship case, we'll pretend it's a guardianship case in New York, along with your petition for guardianship that you filed, you will also be filing either at your first appearance or at a subsequent appearance, which will actually be a mini hearing, a motion for special findings. And that's a motion here in New York. It's a general form, General Form 42, that's also found on the New York State Family Court Forms website. But what it is a special findings order that lists all the elements of special immigrant juvenile status, so that the young person is under 21, unmarried, abandoned, abused, or neglected by one or both parents, and you'll put more information into that, specifying which parent or both, and so on and so forth, not in the young person's best interest to go back to the home country. So you'll have that order, and to support that order, you'll have an actual memorandum of law or an attorney affirmation if the child is very young. You'll have an affidavit from the child, and you might actually have an affidavit from the proposed guardian as well in support of this motion that you're making to the court that your order for special findings should be granted. You need this special findings order in order to do the immigration portion of special immigrant juvenile status. This is what SIJS, or the United States Citizenship and Immigration Services, is looking for, along with the letters of guardianship or the custody order, in order for this young person to be granted special immigrant juvenile status. And one important thing to note is that the language on the order, it must follow the statute verbatim. So in New York, we have the luxury of having this form available to us as a general form on the court's websites. In other states, it's not, and so it's just very important to follow the federal language that's there to make sure that this form will be able to be used for the child for immigration purposes as well. Okay, at the actual hearing for special findings, you need to prepare that young person for the hearing because, as we all know, talking in front of a court is not something that often comes naturally to people, and it doesn't come naturally to children. So you're going to work with that young person on a brief direct of the young person and also the proposed guardian as well, because you want to articulate for the record in the family court all the elements of special immigrant juvenile status. So you'll ask the young person's age, and you may ask the young person, what is your marital status? But before, you will have talked to the child and defined what marital status is, because what we found is a lot of young people don't understand that term. So you'll talk about the appropriateness of the guardianship. What do you like to do with your uncle? What kinds of activities do you do together? And have testimony come out from that. And you'll establish that it's not in the child's best interest to go back to the home country, and you'll also need the child to talk a little bit about abuse, neglect, or abandonment, what happened, and why that young person can't reunite with that parent. So it's very, very important to prepare the young person and also to prepare the proposed guardian for the questions you might ask, and also to prepare them for the fact that it's the judge's or the referee's courtroom, and she may interject at any time and take over the questioning as well. Okay, so at the hearing, you're going to establish all of this. In rare cases, the judge will decide the motion on the papers and not require full testimony. It happens in some courts, it's not the norm, and we encourage everybody to be prepared for this hearing. The impact of a special immigrant juvenile status order is the ability to apply for SIJS in immigration purposes, and that is something that will actually lead to a petition for lawful permanent residence, which is an application for a green card. So the special findings order from the family court doesn't guarantee that the young person will receive permanent residence, right? This is a determination made by SIJS, made by immigration. The state court, the family court, is doing what is in its purview, which is granting the letters of guardianship and saying that it's not in the best interest for this young person to go back to the home country, but it's not making an immigration determination. Again, we're not providing the important takeaway also, and something to reiterate to the young person is that if the young person receives special immigrant juvenile status, he or she cannot petition for the biological parents in the future to receive any kind of immigration benefit in the United States. So after we have our I-360, I-360 is the name of the form for special immigrant juvenile status. So that's an immigration form, and that's on the USCIS.gov website. After that's been filed and approved, then we can actually terminate the immigration removal proceedings. That's a big deal. That means ending the quote-unquote deportation proceedings in immigration court. After that, the jurisdiction for the young person for the adjustment of status moves back to United States Citizenship and Immigration Service. So you can actually file a green card application for that young person, another huge step. After about 4 or 5 months, then there will be an interview for the green card, and that will be at the local USCIS office. Here in New York, it's actually in the same building as our immigration court, just on a different floor. And hopefully at either the conclusion of that interview or within a couple months later, that young person will actually receive a green card, which is lawful permanent residence.